Recording's in progress. I'm really pleased to be here this afternoon. My name is Amy Cunningham. I'm the Deputy Director at the Vermont Arts Council, and I have the pleasure of coordinating a project that is focused on enhancing the digital capacity of cultural organizations in our state. And this is thanks to funding provided by the Vermont State Legislature last year in acknowledgement of all of the pivots and adjustments that cultural organizations made in the face of COVID and having to shut their doors and figuring out how to reach their audiences and serve their communities virtually. And so many of you did that in the most innovative, interesting ways. And we want to build on that as we're hopefully coming on the other side of the pandemic and really build the toolbox so that our cultural organizations can serve a wide range of communities, either from their home or in their cultural facilities. Really fortunate to be collaborating on many different technical assistance programs. And today's session is in partnership with the Vermont Law School and the Vermont Small Business Development Center. And I am going to let you know, I'm going to put a link in the chat right now that will allow you to see the full breadth, bear with me a minute here, the full breadth of sessions that we have available. Again, many of them are coming up. All the ones that have already happened are recorded and available on our website. Before we get any further, I want to acknowledge that I'm joining you today, and I imagine all of you who are calling in from the traditional and unsurrendered territory of the Abenaki people in the state we now call Vermont. So please join us in acknowledging their history and ancestors, their enduring presence, and their future generations that will live and gather here. And I believe I have covered all of the housekeeping regarding the digital capacity program and technical assistance. And so now it is my pleasure to turn it over to Mercedes, Nick, and Professor Goodenough. Take it away. Thank you so much.
Well, thank you in return. What we're going to do today is I'm going to provide a little bit of a framing. Each of Nick and Mercedes will talk about the info sheets that they have prepared for use by the Arts Council, and we'll then take Q&A at the end. The reason we've done this is to provide some educational background for the new avenues of presentation that have been opened up through the pandemic. One of the things that the pandemic has done is to force us and to some degree stimulate us to imagine new ways of bringing arts out to the community. Typically moving from live to virtual or expanding our virtual offerings. That virtual offering is generally, but not always, through the internet, through the mediation of the internet. And this has been often very successful, and it's something that even as the pandemic wanes, with any luck, we hope to be able to continue and to see this kind of work go forward. But one of the consequences of using new avenues of distribution is it also requires new rights to clear. That much of what we do in the arts is subject to some form of rights in the creator, in the performer, in the companies involved, and these rights are typically licensed in some way when we do performances, performances. And if we are live and we're a venue where we did live art shows or live music or live theater, we are used to the how to get the rights to do a live performance. When we move to the internet, we have now to expand that approach and really expand how we the rights that we license and what we clear to go forward and do these new performances. The rights that we typically are seeing and are going to talk about here start with copyright. Copyright would govern music, it governs theater, it governs other forms of live presentations. It governs artworks that we may see put up, and the rights to display, the rights to link to the internet, the rights. All of those are things which are typically going to be part of copyright. We're also going to be a little concerned about trademark. Again, sometimes an arts organization will have its own trademarks. Sometimes it will be using trademarks of other individuals, companies, etc. And those will need attention as well. And the final big topic is the rights in personality, the rights that people have in the depiction of themselves. So if they're actors, if they're singers, if there's musicians, again, it can be sometimes necessary to make sure that those rights are granted, and are granted with respect to the internet or other media use that is going to be made. The key and really a relatively simple framing is, when one is migrating art presentations of various kinds to the internet, to a virtual world, it's necessary to first of all figure out what are the rights that are added that need to be cleared from this. And then secondly, make sure that the documentation grants those permissions, grants that clearance from the necessary sources for all of those different rights. Now, is this something one could do oneself? Perhaps, particularly folks who are experienced in this world, and all. We on these information sheets that we will be presenting, there are links to further resources that could be guides for some of that. But it also is an opportunity for engaging with a lawyer is not a bad idea. We are a law school. We are lawyers or lawyers in training, and with any luck, we can help add some value. Lawyers can help add value in this by providing you with some guidance as you go forward on this. So DIY, okay, maybe possible, but I would also recommend that consulting a lawyer is always going to be a good idea in this, particularly the first few times out. There are some programs for offering a discounted or even pro bono services to the arts, and those can be worth exploring. Nicholas, are you in a position to take us away with the first one of these sheets? Mercedes and Nick have done some very good work this term as part of their work with this class to prepare these short introductions to the additional rights that may need to be gotten. These sheets are available through the Arts Council, but we thought we would work our way through them a bit. Nick, if you have those ready.
I do. Let me share my screen, and I'll get the art. It's not allowing me to share my screen right now. Host disabled participant screen sharing.
Host, would you be able to give Nick the screen sharing ability? That would be appreciated.
Got it. Thank you. Can everybody see that? Yep. Okay.
Great.
So, Professor Goodenough, thank you for the framework of this project. The internet is a great thing. However, when you put stuff on the internet that's not typically on the internet, you can come across some issues. So, for example, an online art gallery, when you stream an online art gallery, it's going to require certain clearances that maybe someone who has done loads of in-person art galleries haven't thought of before. So things that some rights clearances for streaming paintings or drawings, the artist may want to consider copyright clearances for the artwork itself. When the image is posted online, the high resolution images depicting the art could require a clearance. Paragraphs that describe the art, and and maybe some trademark issues can come about. So when there's an exhibition or an art gallery that's posted online and streamed, copyright clearances are generally needed for the online expedition. And how that works is you usually there is a release that needs to be filled out. And in a little bit, I'll show you an example of what a release will look like. And in fact, that resource is down. It's the first resource down below that everybody will have access to. And so these releases are what allow an artist and an artist who is displaying or streaming an online art gallery or exhibition to not infringe on other people's copyrights, but also it protects their own work. It protects their own clearance. It protects their own copyright rights from other people using their videos. And so when somebody streams a piece of art, not only are they an artist in the sense of painting or drawing something, but they take on this role of a producer. And what that means is that they'll have to get clearances for that video itself, in addition to the art that is being shown. And so these clearances could be copyright or trademark, and even releases for people that are involved in the video if people are shown. And so I'm going to show you what a release for a video looks like. Again, this is the first link on that flyer, and just walking through it quickly, you can see that there's some pretty standard language, but it's important to include the names, who you are.
Nick, it's not on my screen at the moment.
Oh, you're not seeing it? Okay.
No.
Hold on a sec.
Well, Nick is pulling that up. The rationale behind these clearances is twofold. One of them is that there we go, great. One of them is that there may well be a video, a kind of a produced video involved, as if it were a production, and that produced video will need the kinds of clearances that a normal produced video would. But also, one of the copyright protections for a work of art is the artist, the creator of the work of art, controls the display of that art. And the depiction on a website, on a video, would be a kind of display, and it would be in addition to the normal grant of rights for display in a gallery. This would be a grant of rights for display not only in a gallery, but as Nick has said, on the video as well. Anyway, Nick, if you want to just point out here on this form a little bit.
Yeah. So again, this is one of the links provided on the flyer, and just walking through it quickly. It's important to just include the names of the people that you're trying to get the release from, your name, and getting their signature, maybe specifying an amount that they're willing to release their video, their rights for, and basically very standard stuff, gathering information from both parties. And in fact, on this website, you're able to download a PDF and do add stuff, add your information in.
And again, we're not necessarily endorsing this form. We think that use of it with a lawyer is a useful thing, but it does provide an illustration of exactly the kind of thing you're doing. There was a request for providing these. This is the link that is at the bottom of that information sheet, which is available through the Arts Council. So again, an arts exhibition. You need to think beyond what has been the kinds of permissions that an art gallery or an artist would normally assemble to do a show, and begin to think about what would be necessary to put it online, both the art itself and if there is accompanying documentation, accompanying video content, what would be necessary for those as well. We'll do some Q&A at the end, I think, rather than interrupting. But please send questions through the chat, and we can respond there as well. Mercedes, would you be kind enough to take us through the similar sheet that we've prepared for music clearance?
Yes. So this sheet, it talks about everything music. So during the pandemic, we saw a lot of innovative and unique avenues that entertainers took to keep us entertained while we were being in quarantine. So we've seen concerts online, music events online, and they were all in entertaining ways that we haven't seen before because we were so used to going out and being a part of these things. So I'm going to start by talking about some of the rights of songwriters, because their rights translates to the licenses that organizations will need to stream or hold music concerts. So a songwriter has performance rights, and this governs the performance of their music, whether it's by themselves or by others covering their music. They have master's rights, and master's rights cover the right to reproduce a specific recording of a song in a visual media. And they have sync rights, which covers the synchronizing of music with images of video or film. And all these rights are protected by copyright. So if an organization is getting if an organization is not getting formal permission, it may be subject to a copyright violation. So like I said prior, these licenses, they're translated through the rights needed. So an organization would need to obtain these 3 licenses, or at least these 3 licenses, to hold virtual concerts. They need a sync license, a master use license, and a public performance license. It is good to note that if an organization is holding an event or a concert on streaming platforms such as YouTube, Facebook, Instagram, these platforms, they will already hold some or all of the licensing agreements that you may need. So it's let's work on the organization side rather than them putting it on their own website. So in the resources column, the last row, you'll have templates for sync and master use license agreements. And the organization would basically fill out that information, and the agreement basically details what is being cleared, so the scope of the license. Towards the end, of course, you'll have both parties sign, and that would be your license. I would like to reiterate what Professor Goodenough said, and this is a template, but it is good to see a lawyer to have a better understanding of what you're getting into. As for performance licenses, these licenses are usually given by 3 major companies, and it is ASCAP, BMI, and SESAC. And these are known as performing rights organizations. So they organize, these organizations, they represent the rights of songwriters and publishers and their right to be paid for public performances of their copyrighted music. So these organizations have made it easy to just request and obtain a public performance license. You'd basically go to one of their websites, fill in a simple form, and then the form is submitted. After that form is submitted, a representative will contact you by phone or email with more information. The bottom line with clearance for streaming music is musical composition are protected and covered by US copyright. So this is true whether it's in person or virtual concert. So an organization should always just make sure they're dotting their I's and crossing their T's to ensure that there's no copyright violation.
Thank you, Mercedes. If I could just add on a little bit. As she has been describing, this there are more rights than people who do live concerts might be used to clearing. Folks who have done a lot, been in the live concert business, typically are concerned about clearing those performance rights and may have contacted ASCAP, BMI, or CSAC in the past on that. But in addition, when a concert or set of performances is put into video, there are these additional video rights to clear, as was mentioned, the master use and the synchronization licenses. And the sources of these can be different from ASCAP and BMI and CSAC. Again, there's a little more work that has to go into making sure all of that is taken care of. By all means, the performance license will be necessary, but the other licenses as well. Mercedes, anything in addition you would add before we move back to Nick and live theater performances?
No, I just want to point out that the resources on the bottom is really helpful. There you will see that other blogs and articles about just the licenses in general for virtual concerts. So those are really helpful.
You're here. Nick, you were going to tell us a little bit about the live performances of theater and related kinds of performances.
Yeah, exactly. Yep. Similar to what Professor Goodenough said. There are additional licenses that are clearances that streaming a performance requires, and specifically the producer should obtain a performance video and recording distributions license, and that includes any of the music involved with it. And there are certain agencies that will have that will grant these rights. And so again, there are the classic licenses that the performance needs. So not only will you have to go to the clearinghouse to obtain the rights to produce the play, but you're gonna the person who's recording this and streaming it online is going to have to do the distributions license for performance video and recording as well. And so again, the worlds of IP law that are involved here are copyright, and again, because it's being videoed and streamed, trademark can be trademark and personal rights of the people depicted are also involved. I also have another link to show on this, and let me just pull that up. And this is what an artist release form looks like. Again, this is just an example of what one of these can look like. We're not suggesting that this is the one to be used, but again, pretty standard language where there are certain places that can be filled out and used.
Yeah, Nick, I think this form in particular would be for works of visual art, but similar kinds of releases would be involved potentially with works for theater and that kind of thing. So musical theater in particular is full of this, because you have to clear the rights to the whole package of theater and music as well. It's also worth remembering here, and as in all these cases, that the individual clearances may be for people depicted, but also for your actors and for your designers and your directors. All these people involved a performing arts organization should think about getting clearances, should think about who is necessary to get permissions for, and those permissions should be at least as extensive as the planned uses that are going. Sometimes releases can be even broader than the planned uses, and if a performing arts organization can collect those, well, that's terrific too. But at the very least, a set of permissions for the people, for the artwork, for the creativity, for the script, for the music, all of those need to be cleared with respect to the intended uses. So I would summarize by saying, first of all, again, as we've seen in each of these contexts, there are rights that are in addition to what folks who are used to putting on live shows, live performances, live art shows, all of those rights that people are used to getting for a live performance. There are typically additional rights that need to be cleared for each of those if they go online or in some other remote platform. As we've discussed in these one sheet takeaways, they provide a summary and an overview of what those additional rights are, and a set of initial resources to follow up with, to educate and see examples of what those things could look like. Are there any additional comments either from Nick or Mercedes, or before we open it up for some question and answer from the group more generally? Okay, great. We would, if there's some questions in the chat, that would be great. Our colleague Professor Killoran has been monitoring the chat. Professor Killoran, do you have a summary of any of that, or should we just go to the chat and have a look?
There is not currently anything in the chat. In the Q&A, we have someone who's posing two questions. The first is, where do you find a lawyer who specializes in these topics?
Oh, what a good question. One of the answers for that is to go to the Vermont Bar Association. Has a legal referral service, and that they can help you find folks who specialize in that. Vermont is not wildly populated with people who have that expertise, but they do exist, and that the Bar Association would be a good starting point. You can contact us at the Vermont Law School, and Nicole, do you want to describe briefly some of our possibilities for referral?
Sure. We have we can provide a more extensive educational session if folks are interested. We have also some funding for qualified businesses. We have some funding that's hoping to lift up LGBTQ-owned, BIPOC-owned, rural businesses, veteran-owned, women-owned businesses in particular. And that may also be a source of funding to pay for 5 to 10 hours of legal services. So we would be happy to provide an additional education or to help with those services. There's also, of course, always word of mouth. I am not sure if the Vermont Arts Council has anyone, any lawyers in particular that they might have in a Rolodex, so to speak, but it is common for some industry-specific organizations like the Vermont Arts Council to have some suggestions for lawyers who are in the state who can do this kind of work or who are accustomed to doing this kind of work.
Amy,
Amy Cunningham, do you have any resources for the Vermont Arts Council there?
Right, thank you. We do not carry a roster of recommended lawyers, but we are exploring, there is a national organization called Volunteer Lawyers for the Arts. There is not a chapter in Vermont, but we'd very much be interested in getting one started, and might follow up with you, Professor Killoran, about how we might get that kind of going.
And I would
Sure.
mention that I myself am not licensed for practice in Vermont. I'm licensed for practice in New York, so I cannot give advice in a Vermont context. But I have myself significant experience in representing folks in this. I'm a co-author of a book called This Business of Television, which summarizes a lot of this kind of material. And I would be happy to participate, as you've heard, in an additional, more specific education education sessions for folks with questions through our programs, but also would be happy to be a resource for a Vermont-based attorney who was hired under those circumstances. As we can provide guidance and education and to the lawyers as well in this context, if there are lawyers who would work with the people.
And the truth is, anyone who pardon me, who has passed the bar is a competent lawyer. And as you can hear, there's some common themes throughout some of these needs. There's licenses and releases, which are generally contracts or waivers. And so to the extent that there's specific language that's necessary to protect one's rights, that's where having an expert like Professor Goodenough would come in handy. But otherwise, most lawyers can generally tackle a lot of the service needs that artists have. And so while it's nice to have someone who specializes in a particular area of law, it is entirely possible to work with a lawyer who can become somewhat of a nominal expert in it, or at least develop some experience that helps the artist. The second question from the Q&A was, what do these types of protections, licenses, et cetera, cost? Small businesses need to plan these into budgets. What is the general cost for these sorts of transactions?
Quite variable, quite variable. Now, and it depends on the scope. For instance, if one is putting on an art show of an artist's work, if somebody is organizing a virtual gallery and saying, hey, artist, would you like us to put this on? My expectation is that the artist might be very eager to say, yes, please do that, and we'll sign I'll sign a release and as part of that, and say thank you rather than charge. If you're putting on a live musical theater piece, that can be significant. Again, if one's trying to do My Fair Lady or some other Broadway show, if one is used to doing it at a high school level and paying the some hundreds of thousands or maybe a few thousand in royalties for that, to have a live show at the high school, to put that live show on in a recorded version onto YouTube may be rather more expensive. Because now it suddenly competes with everybody else's production nationally and not just locally. So again, that can be more expensive. It's quite variable. Some companies have caught up with the pandemic and the need to be virtual. Some companies have not. I apologize for not having a direct figure, but that's the kind of thing just exploring early rather than late. So it would be a shame to go, oh yeah, the high school's going to do My Fair Lady, or the community organization is going to do My Fair Lady. Do we need a license when we stream it? And the answer is yes, and you should have explored that before deciding to do that and publicizing it and getting it all set. So check these things out early is a key element, so that the pricing can be built in, or if it's going to be too pricey, some other plan can be made. Is that adequately responsive?
I believe so. The person who posed the question says, thank you for the answers, very helpful, so much good info, and agree on checking early.
And the chat, there was in the chat, someone had a relatively complex question, which we could
yes. We are eagerly awaiting its arrival.
Yeah,
I have a simple, I think what may be a simple follow-up question to give the other person time to type their question in. I was curious, Mercedes, that was really interesting on the different streaming services. And you mentioned the idea that in the case of streaming, if an organization is streaming something via YouTube or Facebook Live, for example, that there may be existing licenses or agreements held by the streaming organization, YouTube or Facebook Live, for example. How would I, as a small arts organization, go about finding out what kind of licensing they have? Does that make sense? Where would I start for that?
Mercedes, do you have a lead you could provide people on that?
I am not 100% sure, but I think you would find that just by looking at just by asking YouTube, basically just looking at if you Google it, like, what licenses does YouTube hold, you could see that. And that's how YouTube is able to like have all these people doing like unofficial music videos or covers to different songs, is because YouTube already holds these types of licenses.
And often we'll link it with an ad. If you go to YouTube, sometimes it's linked to an ad, and they share those ad revenues with the rights holders, which is how they are able to do that. But again, it would be typically through some kind of a large arrangement with a rights holding organization of some kind, whether it's one of the ASCAP, BMI, or CSAC, or some other arrangement for that. And it would cover the performance piece, but would not independently necessarily cover those two other pieces, the master use and the synchronization license, which actually cover the creation of the recording. Copyright law is a little bit sliced up that way, that there are the rights you have to get to actually create a recording, master use. There's the rights you have to get to then link that recording to a video of some kind, which is the synchronization right. That's where you're synchronizing the sound with the video. And then finally, there's the performance rights to actually just put those out in some kind of public venue, either live or over a broadcast or an internet or some other form of electronic distribution. So that's one of the things that's confusing, because people sometimes think, oh, I got the performance right, I'm done, right? And the answer is, well, not necessarily, because they do slice and dice these rights up, and you have to get the whole package, as it were. And sadly, the whole package is not always available from the same spot. So YouTube may be able to help you with that performance license, so you don't have to go yourself to a CSAC or a BMI or an ASCAP, but it probably won't do the problem of the other rights as well.
Thank you.
You're welcome. Nicole, do we have that?
We have our complicated question. So this is
Okay.
this is about well, copyright and trademark infringement. Very specific question, but complex. One of my hats is, I believe, watching copyright/trademark infringement for the works of illustrator Tasha Tudor, who published around 100 books in her lifestyle. Someone developed an online course which used her name in the course title and used her books in the course, pre-recorded video course. Could be purchased for $99 to $150. Since Tasha Tudor's name was not trademarked for a video course use, her attorney said she wasn't infringing. Found the expense of professional defense to be unaffordable. Reactions?
Two or three things. We're not in a position to give advice on a particular matter, sadly. But as a general matter, the use of copyrighted works in video is a use of that work. It's a reproduction. It's a distribution. It is a derivative work. There are a number of different ways in which the use of a copyrighted text or illustration would be likely to be a copyright problem for the user. Again, there are doctrines like fair use, which can excuse some pieces of it, but those fair uses are very sort of fact specific and would need to be looked in to and for whether or not they would justify. The use of a name is an interesting question, because it gets complex. Names typically are actually not covered by trademark. The names would be covered instead by a set of laws that are often called rights of personality, which include the rights of privacy and publicity. Those are state level rights, and they vary significantly from state to state. Some states provide a protection after people have died. Some do not. Again, very state specific on those rights. In addition, those rights come with a right to an exception for sort of factual use and criticism and that sort of thing. So if I wrote a piece of criticism of an author's work and then use that in title in the author's name in that criticism or in a course relating to that criticism, that could be an acceptable sort of First Amendment style factual use, which is often accepted from these. So again, it's a very complicated question depending on what law applies, and it's typically the law of domicile of an individual, and it's the law for deceased individuals. It's typically the law of their domicile when they died. So again, it's quite a variable on that. There was a theater named in New York City. They named a theater for Tennessee Williams, and then his estate, I believe, objected. And it was a question that was it Florida law, was it New York law, was it descendable? In New York, these rights are typically not descendable. In Florida, they were anyway. It becomes a very complicated question in a hurry. One of that should not be an excuse, however, for people getting away with violating people's rights. So again, I would think refer, these can be costly to do, but copyright violations actually come with what are called statutory damages, and statutory damages can be significant and can be a reasonable hammer to help pay for a lawyer if they're recoverable, and B, get people to behave. By the way, if you're thinking about being the producer who is going to do rights, statutory damages is another reason to make sure that the producers clear the rights as well. So it can be used both as offense, and we need to remember that when we're playing defense, we need to be concerned about those. Is that a useful answer to the complicated question, without getting into the specifics of the case?
I'll let our attendee respond to that, but it occurred to me, Professor Goodenough, it might bear a brief explanation of the difference between copyright and trademark. And there was a point in this which highlighted that particular things have to be trademarked for particular uses.
Trademarks are intellectual property that applies to designation of the origin of goods and services. And so it can be used in a classic good, like a product like Coca-Cola. Coca-Cola is a registered trademark of the Coca-Cola company, and to sell soft drinks with the label of Coca-Cola, you need to be Coca-Cola, because that designation of the origin is reserved to the Coca-Cola company by use and by registration of the mark. In an arts context, this is sometimes the case with things like a particular set of books. One cannot copyright a title of a book, but a series of books could have an overarching description, and could potentially be trademarked. So, for instance, the Harry Potter books could potentially be trademarked for the Harry Potter books, or the Hogwarts could be trademarked, and various kinds of goods and services, various kinds of merchandising rights and things could depend on that. So again, the trademark is not as generally applicable to these kinds of online performances, but if it was the name of a band, which can sometimes be trademarked, or the name of a character, or of a merchandising piece or something like that, that also, there may be a trademark. And trademarks are subject to both registration, which gives extra protection, but also to just some protection by use if they're being used to designate goods or an origin of goods or services. There can be some protection that comes there. Is that an adequate set of explanation on that?
Looks like responsive, all interesting. Thank you. It struck me that it might be possible to trademark something for a particular medium of art, but then for it to be used in a different format. I wasn't sure if there's any extensions for the trademark there, but it sounds like there is.
Yes, no, that would be interesting. So, for instance, some of the Andy Warhol art, for instance, raised itself to a level where it was not just the image itself, but became a symbol of Andy Warhol style stuff. So again, that would be a kind of a context where it was, and artists may choose to use a particular work that's iconic of them as a trademark for their. By the way, when you say we trademark something, that's actually a shorthand that we sometimes use, often meant to say, did we register it? Because some trademark protection occurs just from use, and in that context, if one wants to add the initials TM, can be useful. It strikes me, by the way, that if given the interest level we're seeing here, and I apologize for thinking on the fly here in a public context, but Amy, we might think of a sort of an intellectual property 101 that was a little more general and not just aimed at the internet, the way this and the virtual performances, the way this has been done. That may be something we could follow up with.
I think that would be incredibly helpful. Yes, thank you. We're all juggling lots of questions around, and many of us have been working in kind of pseudo educational contexts and thinking. I think some folks think about fair use with a broad brush, and we don't actually know where our boundaries are there. So I think
fair use is, as we mentioned in this, is out there. It can help some things. It doesn't always help where all you might wish it to. And if you're on the artist side, again, you may want to say no, not fair use to do that. So yes, that could be a topic in and of itself. But to summarize again, as Mercedes and Nick and I have hopefully been able to lay out for folks, there is this when you in any use of creative work by people that isn't their own, that it is always worth considering. Do I need to get permission from the person whose work it is? If it's a live artist, if it's it's a visual artist, if it's a creator of theater, or a creator of music, or a performer in theater or music, all of those are places where that idea of kind of clearance comes into play. And people who are used to getting clearance for live performances, for all of the things we did 2.5 years ago, right? People who are used to that world need to get used to the additional layers that come with putting it on the web. And as pointed out, sometimes that costs a little more. Sometimes it costs a lot more, even worse. Sometimes it can be free or inexpensive, but it's one of those things where just taking care of it is important. As Nick mentioned, the person who is sort of putting this all together now has to think not just like an art gallery or a local live theater producer, but has to also think about being a video producer. And it's what the things that come with being a video producer that are then that sort of the video producer needs to step up to the plate and make sure those are covered, either by some kind of release and permission from a place that has the authority to grant them, or sometimes through a fair use justification, but the person involved should know why that fair use justification works.
There's an interesting question in the chat on that topic. That this might be a good place to address it. Can high schools record performances for teaching purposes and share the recordings with the performers for this purpose? If so, what types of disclaimers must accompany the sharing of the electronic video?
What a good question. And before giving a definitive answer, I think we would need to research that a little more, because my guess is there's some actual experience out there. Reasoning from first principles, there is an exception in the under the fair use standard for educational uses. Now, that is not an endless exception. There are boundaries on that. For instance, it has been held that you cannot simply photocopy a textbook and hand it out to your students and say, educational uses. No, it has to be reasonable, and it's typically thought of as kind of spontaneous one-off use in classroom, etc. Now, the use of limited use of a video to kind of coach people and that kind of thing, again, might fall into fair use. I could imagine, again, reasoning for first principles, that might be there. Recording an entire show starts to get a little harder on that one. Recording an entire show and giving it to everybody who was in it, gets a little harder. And certainly anything that was ever done in that context would want to be very, very carefully circumscribed so that the distribution was limited to that educational purpose and didn't include everybody's aunts and uncles. That would be the case. From a practical standpoint, by the way, I'm not advocating this at all. From a practical standpoint, there's sometimes will anybody object is a question that the people ask themselves. And that's a little bit when I teach intellectual property, I say it's a little bit about do you drive on the interstate above the speed limit? As a lawyer, I cannot say that's a good idea. As a human being, we all sometimes do that. But the cop can pull you over at any moment. And that this is true of these kinds of copyright and other artist rights violations. Is the cop can pull you over, and that's not going to be great if that happens.
Excellent answer. Thank you, Professor Goodenough. We do not have any additional questions. Q&A in the Q&A box or in the chat right now.
Okay.
Do we want to wrap up? Any final words from our students or Professor Goodenough?
Students, we're the primary authors of these information sheets. Thank you so much for doing that. Thank you so much for presenting them here. And again, we can perhaps consider a couple of one or two more generalized sessions as well.
All right, Amy, any closing words from you?
Just a lot of gratitude to Mercedes and Nicholas and Professor Goodenough, and these will be really useful resources for the field at large. We will, on the same page that I posted our technical assistance workshop sessions, that's where we'll have links to these actual flyers so folks can use them. Thank you.
Thank you. And if you end the recording, we have a question in the chat from Amy Tudor who says, not to extend, but I'd love to hear from the students and what they're studying or planning to focus on. So Nick, Mercedes.
Have we ended the recording now?
I'm not sure. No, we're still recording.
Before we do that, we should.
You want to stop the recording now?
Yes.
Yes.
Okay.